Mr. Vani?
Chairperson, I'm advised by the NPA that Mr. Gwala, who is online, has one further question he would like to pose.
Mr. Gwala?
Good morning, Chairperson, and good morning to Commissioners. Thank you for accommodating me and thank you for the indulgence. I have one aspect to deal with. It will take about 5 minutes or less. If I may, Chairperson.
Yes, you may.
Thank you. Mr. Ackerman, good morning. Can I ask you to take the NPA bundle? We did deal with it yesterday briefly. And please tell me when you found it.
I found it.
Okay. Could you please turn to page 17 of that bundle? Please to tell me when you found the page.
It appears to me that there's some difficulty finding it. What you just now asking Mr. Venter.
Okay. But perhaps I can just read it out to save time. It's
I've
not.
got it.
You've got
Got
it.
it.
Okay,
Yes.
thank you. Yeah. That is a memorandum dated 5 June 2008. You see that?
That's correct.
And the subject is TRC task team.
That's correct.
It is from yourself to Dr. Amaite.
That's correct.
Yes. I just want to take the first paragraph there. You say, "Dear Dr. Amaite, with reference to the meeting between you, Advocate Makadam, and myself earlier this morning, I confirm the following. Number one, that Advocate Makadam will supervise and manage Advocate Maga's activities in respect of TRC matters." Do you see that?
That's here.
Yeah. Would it be fair to conclude that as at June 2008, you knew or you were aware that Mr. Maka was in fact working on the TRC matters?
Yeah. He was working on a lot of TRC matters.
Say that again?
He was working on quite a few TRC matters.
Yes. All right. An assertion that you did not know that he was working on TRC cases until recently would be incorrect.
If you say recently, I didn't know that he worked on TRC matters.
I'm saying an assertion that you didn't know until recently that he was working on TRC cases would be incorrect.
What's a recently? You hear what I'm saying? What is recently?
Before these proceedings, for instance.
I did not know, if you're referring to Mr. Mshe's letter to Reverend Shakani, where he states that he took me off and he has appointed Maga Ramayiti and the task team to manage the TRC meetings. I was never informed by any person that that is a position.
But in 2008, June, you would have known that.
In 2008, from, I don't know when he started, was it in 2005 till I left in 2013, he was probably working on TRC matters if he was still employed to this. All the time, he's not working only on TRC matters. There are quite a few other matters he probably worked on too. When I see a good case that will fit in, I will give it to him, not relevant to relation to TRC matters.
Thank you, Chairperson. Thank you for indulging.
Thank you, Mr. Kwala.
Thank you.
Mr. Vani.
Thank you, Chairperson. Can I just check, Commissioners? Can I be heard?
Yes, you
Am I
can
loud
be
and clear?
heard.
Mr. Ackerman, can you hear me?
I can hear you.
Okay. Perhaps let's just start the re-examination by referring you to the statement of Advocate Maga. I don't. Perhaps Mr. Fenter can secure the statement of Advocate Maga, so we can just explore the point just raised with you by Mr. Gwala. And once you get that statement, I can take you to a heading on page 21. It says the period 2007 to 2009, paragraphs 77 and 78. Just to save time, I'm going to read the relevant extracts and you can comment. Paragraph 77, from late 2007 until approximately June 2009, there was a marked decline in progress on TRC-related matters. As a result, the TRC task team became largely dysfunctional, and my role within that structure was effectively rendered redundant. And then skipping to paragraph 78, this was a professionally difficult period characterized by a lack of prosecutorial work. In an effort to maintain my courtroom proficiency, I requested my former DPP, Mr. Lusu, to permit me to undertake circuit court work in the Transkei. He says, on his return to Pretoria, I requested Advocate Ackerman, SC, to facilitate my secondment to the Specialised Commercial Crime Unit to broaden my experience. Do you recall that?
I don't recall that during that period, but I know of it, that he wanted to do some litigation that I know, and there were no litigation work at that stage. I was also under the impression that he worked on quite a few cases in the Eastern Cape. I don't know at what stage, but there were quite a few cases that he managed in the Eastern Cape. But that sounds, I'm not going to dispute that.
Yes, it was the evidence of Advocate Maga before this commission when he testified last week that because of the lack of investigative capacity at the PCLU, the TRC cases were not being taken forward, and as a result, he was not being exposed to work in court, which prompted his request.
Yeah, and I think what played a role in not investigating those matters, there was a instruction direction from somewhere because of the Ginwale Commission. We must wait for the Ginwale Commission to make a findings on certain matters. I think that was also a reason why it was no progress was made.
All right, let's return to your evidence under cross-examination by Mr. Gwala yesterday, he asked you when political interference started formally, and you mentioned that the terms of reference don't speak of political interference or even interference, but rather whether efforts or attempts were made to influence or pressure to stop the NPA or SAPS from pursuing the TRC cases. And according to my notes, you mentioned that you regarded the denial of investigators as a form of interference, and the intervention of the Minister of Justice directing the acting NDPP to suspend work pending the guidelines as political interference. Mr. Gwala then put it to you that this was just a mere temporary pause, and you mentioned that the suspension was about 2 years because the prosecution policy amendments were promulgated in December 2005 and came into effect during 2006. Now, I want to ask you whether the suspension was in reality temporary in practice, given that between 2008 and 2010, Advocate McAdam was still pleading with the SAPS for investigators. And from records before this commission, since the Chikani case in September of 2007, the plea and sentence agreement, which went ahead amidst much controversy, there hasn't been a single prosecution or inquest in respect to the TRC cases until 2016, when Nokutul Simelane case was enrolled. And this was only after Tembi Simelane went to court to compel a decision. So a period of inaction for nearly 10 years. In these circumstances, Mr. Ackerman, can it really be said that in practice the suspension of the TRC cases was just temporary?
No, I agree with the statements you've made.
Now, it was put to you by Mr. Gwala, and now we're returning to the evidence of Mthunzi Maga, that notwithstanding the obstacles, such as denial of investigators and the moratorium imposed towards the end of 2004, that Advocate Maga was able to successfully proceed with the case in 2005. And I understand that the suggestion was that if this case went ahead, then all the other cases could have gone ahead. Now, in fairness to you, you should be given the basic details of that case. It related to the murder of one Zokwe, an MK cadre, by the Transkei Security Police in 1988. That case was not with the PCLU, but with Advocate Maga while he was at the Mthatha DPP's office. Now, the investigations and the prosecution itself commenced before 2005, at least during 2004, if not earlier. And at that point, Advocate Maga was not with the PCLU. Now, is it correct that following the declaration of the TRC cases as priority crimes, most of the dockets were transferred to the PCLU?
That was direction by Mr. Nuka that it had, but I was not aware of that case, and it never landed on my desk. That's what I said yesterday, that I believe that's probably a case that was in Mthatha. I know there were also cases in KwaZulu-Natal that had the same fate.
And is it also correct that the denial of investigators, from 2003 onwards, was directed specifically at the TRC cases held by the PCLU.
That is correct. I may add that all prosecutors, like for instance, Mr. Marga, you have a person in your district that you know and that will do some investigations. I don't even think they were aware of the fact that there was a moratorium on the investigating TRC matters. I don't know what happened in the Transkei, but I know he prosecuted that matter.
Yes, and we heard the commendable work he did and the attempts against all the odds to pursue these cases. And if I recall his evidence, he said these were special efforts that he made, notwithstanding the fact that he didn't have investigation officers. I don't know whether you heard that evidence.
Yes, I don't know what time it was. If it was during my time, I would have given them the go-ahead just to canvass all these cases that we have. So in the event that investigators become available, that we can immediately proceed. It makes sense to me. At this stage, I can't recall who gave him that direction to go and investigate it in the Eastern Cape. He was from the Eastern Cape, and I usually gave him the cases that were in the Eastern Cape area.
Yes. Well, his evidence was actually you who issued the instruction that he should go down to the Eastern Cape and do what he could. And to his credit, he was able to engineer a plea and sentence agreement in one matter in 2006. And he has set out other matters. We're not going to go through them, but essentially he says that they suffered the same fate as the other TRC cases because of a lack of investigative support.
In an audit report that he submitted that he probably drafted, you will see he was involved in quite a few TRC matters where he put his name in brackets that those are his cases.
Yes. Now, the instruction in November 2004 to suspend the TRC cases from the Minister of Justice to the acting NDPP, Advocate Ramaite, which in turn was relayed to you, am I right in saying that applied specifically to the cases held by the PCLU?
That's correct.
So if we can just return to that 2005 case, which Advocate Marga worked on before joining the PCLU while he was in Mthatha. It was known as the Chiani case, Chiani. Chani. I understand the spelling is Tiyyani. Would it be correct to say that that case was an outlier or an exception because it wasn't on the books of the PCLU? And most significantly, the investigations commenced before the moratorium was imposed in November 2004.
I did not even know that it was a TRC matter. As far as I recall, he said he's got a case that has been remanded and postponed, and the case was adjourned. If I recall, he never told me that this is a TRC case that I am conducting in Mthatha, wherever it was.
Now, yesterday Mr. Gwala criticized you for not prosecuting those behind the blocking of the TRC cases, and he put up as an example your discussions with attorney Jan Wagener, who was representing members of the former security forces, who apparently told you that the former generals had been meeting with the ANC leadership to come up with to search for a political solution to prevent prosecutions of the security forces. Now, would I be right in saying that what you heard from Attorney Jan Wagener was hearsay? And would that have provided a basis for a prosecution against anyone?
It is hearsay, but even if it was proved, I was not going to lay any charges against them at that stage. Because there are these altercations, what happens in court.
Now, in relation to what efforts that you and then NDPP Advocate Vusi Pekoli took once you were facing these challenges, am I right in saying that you didn't sit on your hands? It was raised with your superiors. And am I correct in saying that you and Advocate Pekoli appeared before a Justice Portfolio Committee meeting on the 3rd of May 2007, in which Advocate Pekoli raised the alarm by stating that the NPA was being held to ransom by the former generals?
That is correct. I was present.
Now, Mr. Gwala has put it to you that notwithstanding the fact that those in the task team, this is the task team that was set up after the prosecution policy amendments had been promulgated. So notwithstanding the fact that those in the task team of the DG's forum believed that they should play a role in the prosecution process, the NDPP stood his ground, and it was also put to you by Mr. Gwala that nobody specifically asked you not to prosecute the Chakani case or any other matter, and you did answer comprehensively the opposition that you faced in the Chakani case. I'm not going to ask you to repeat that. And you also referred to the email exchanges between Advocate Maga and Jacobs. And then yesterday in re-examination, I drew your attention to the letter from Commissioner Selebi to Pekoli in February of 2007. Now, am I right in saying that the objection that the NPA had at the time was that in respect of the TRC cases, those in the task team and the DG's forum were expecting the NDPP not to make a decision until he had heard from the DG's forum?
Yes, document speaks for itself.
And
That's
is it
not the only document. There
Yes,
are quite a few documents to that effect. I've seen Mr. Selebi, Mr. Menzies Malani, even during the minutes, there is also probably referring to they must go back to their principles or something to that effect. It's in the minuted in one of the documents.
Yes, we don't have time to traverse all the documents now, but is it correct that you and Advocate Pekoli found this objectionable and an unwarranted interference in the work of the NPA because effectively it meant that your hands were tied until you heard from the DG's forum?
Of course.
Now, Mr. Gwala has put it to you that the deliberations of the task team were not binding on the NPA and nobody succumbed to it, and you could simply have gone ahead with prosecutions. In your view, did the interdepartmental task team ever facilitate the investigation and prosecution of the TRC cases?
No, I haven't produced any investigator.
So they never facilitated the provision of any investigating officers for the TRC cases?
That's correct.
And finally, Mr. Ackerman, we see that the NPA leadership in the mid-2000s, particularly under the leadership of then NDPP Bekoli, an attempt was made to stand up to the efforts to stop the TRC cases. And we've seen that the NPA in 2018, in court papers in the Rodriguez matter, admitted that it had been subject to interference. Now, what do you make of the current NPA asserting that there was no interference in the TRC cases?
They don't know the facts.
Thank you, Mr. Ackerman. No further questions.
Thank you, Mr. Vani. Ms. Moroka?
Mr. Ackerman.
Ms. Moroka, bring the mic closer to you. We can't hear you.
No, it's okay. It's okay. My apologies, Chair. This is not conducive to lots of paper and mics included. I said, good morning, Mr. Ackerman.
Good morning.
I would like us to start off with the foundational laws that determine the powers of the NDPP, your powers, and the minister's powers. And if we could go to section 179, I'm going to try and get to that section 179 and to the NPA Act and ask you to... I haven't finished. And ask you to remember the sections that I've read out to you that we agree on when I then proceed to ask you questions. Would that be okay with you?
That's fine.
Section 179 of the prosecuting authority in the Constitution gives the national director the powers, or assigns to him the power to be the head of the prosecuting authority. That is correct?
Where does it say that?
It says there is a single national prosecuting authority in the Republic, structured in terms of let me finish. Section 179. Structured in terms of an act of parliament and consisting of a national director of public prosecutions who is the head of the prosecuting authority. Would you agree with that? My reading of that section.
There's a sigma structure in terms of the Act of Parliament and consisting of the National Director and busy. Where does it say that that she's the head? I'm just reading on 1791.
1791A. He's the head of
Yes,
the
the national-
prosecuting authority.
Yes, the National Director is, I was under the impression you said Minister. Yes, that's correct.
And if you go to subsection 5, 1795A, it says he must determine with the concurrence of the cabinet member responsible for the administration of justice, and after consulting the directors of public prosecution policy, which must be observed in the prosecution process. You see that?
I see that.
And you agree that's the law?
Well, it says that's the law. It's here.
Yeah. And B thereof says must issue policy directives which must be observed in the prosecution process.
I see that.
And if I do not know whether you in front of you, but if I refer you to the powers, duties, and functions of the National Director, Section 22 of the NPA Act also refers to the National Director as the head of the prosecuting authority. Would you agree with that?
Yes, it is.
Section 2 thereof says, in accordance with Section 179 of the Constitution, must determine prosecution policy.
You're breaking up. Can you just repeat that, please?
And then in Section 22 of the Act, I'm sorry about that, we have to read. Powers, duties, and functions of the National Director, subsection 2 of Section 22, again contemplates that the National Director must determine prosecution policy and issue policy directives.
That's correct.
Now, if we go to Section 22, subsection 4, it says or provides that, and Roman letter 3, it provides that and with the exercising his or her powers in terms of Section 2, the National Director, that is, may advise the Minister on all matters relating to the administration of justice.
Yes, and I know it's may, not must.
If you say that, Mr. Ackerman, can I then refer you to 179 subsection 6 of the Constitution? There,
I just,
you say there the section in the Constitution, 179 subsection 6, provides the cabinet minister responsible for the administration of justice must exercise final responsibility over the prosecuting authority.
yes.
And it's a must
What does
there.
it mean? It's not clear to me what it means.
I'm just letting you know that there's that provision that gives the minister overall responsibility for the administration of justice. Is that correct?
Correct? It says, let's read it, the government responsible.
I beg your pardon?
Just want to read that to see if it's must exercise over the prosecuting authority.
If you could, Mr. Ackerman, I don't hear you.
I say, I don't want to get in a legal argument. It says a cabinet member responsible for administration of justice, that is now we know who it is, must exercise final responsibility over the prosecuting authority.
Thank you. And then subsection 22, if we go back to that subsection, talks to the National Director, I beg your pardon, section 22, subsection 7. The National Director shall develop, in consultation with the Minister or person authorized thereto by the Minister and the Directors, training programs for prosecutors and investigators. That's the law. Am I correct?
Okay, again, I've got it now in front of me. It is 22.7.
Subsection 22, subsection, 22.7.
Okay, I will read it. I've got it here. The national director shall develop in consultation with the minister or person authorized thereto by the minister and the director's training programs for prosecutors and investigators.
Thank you.
Yes?
And if we go to subsection 22.4, it says, with a view to exercising his or her powers in terms of subsection 2. If you recall, the minister is given certain powers in terms of section 179 of the Constitution. The National Act giving effect to the Constitution then directs that with a view to exercising these powers.
Is that now section 4?
No, section 22, section 22.4 of the National Act. I'm trying to show you how.
Yeah, I've got it in front of me, but it will take me 10 minutes to read.
Can I then tell you why I want you to read it? Because the National Act gives substance and content to section 179 of subsection 6 of the Constitution in section 22 in brackets 4. So if you could then read the whole of A of subsection 4, section 22.
Okay, just A.
4A.
Okay. With a view to exercise his or her powers in terms of subsection 2, may conduct any investigation he or she may deem necessary in respect.
May I interrupt? I'm so sorry, Mr. Advocate Ackerman. It is because we don't want to burden the record. I was going to direct you to subsection 2 and 3.
Yeah, so let me see. I must go to subsection 3 now. Unfortunately, I'm here on a computer that Mr. Peter is working. Okay, 3. You want me to read 3?
No, I just want you to just agree that those are the provisions in the Act. I think
I'm not going to
everybody,
agree to this.
everybody in the room has it.
Mr. Ackerman, Mr. Ackerman, just be patient, just listen, because if you talk simultaneously, it just bedevils the transcription.
I apologize.
I was going to say, Mr. Ackerman, you do not need to read it out loud. I was going to give you a minute just to read those sections and then refer you to another section that I want you to also read.
Well, I will, if you can just give me the bottom line, what you want to make, because I can foresee that, after reading all this, you're going to ask me, is it correct that? And then I'm going to say, no, I'm not prepared to give my opinion now.
But
If you give me the bottom line.
Mr. Ackerman, you are being requested just to read, for your own sake, the relevant section that you are being referred to. The questions will come thereafter.
Yeah, I will read
Just
it.
silently
3 and
read.
4. Yes, I've got the gist of it. I just reading paragraph 4A, or must I read the sub-paragraph 4, the whole paragraph? 4.
It was going to be 4. Yes, if you've read 4 and then you go to
No, I haven't finished with
4A. I beg your pardon?
I finished with 3. You said I must read 3, and now I'm going to read 4A. There's 4A, B, C, D, E, F. Must I read all the...
No.
What must I read?
You read 4A, Roman letter 2 and Roman letter 3,
Okay.
and then you read subsection 6A, and that's all you're going to be reading, and then we'll be done.
And then you said I must read after the Roman 2 and 3.
Subsection
Something
6.
else.
Subsection 6.
It's 6. Yes.
Thank you. Can I then refer you, Mr. Ackerman, to your affidavit, the 2015 affidavit, paragraph 1, where you tell the commission, no, you didn't, well, you confirmed, but it was in a different, in different circumstances when you deposed to this affidavit, but it was tabled at this commission. Paragraph 1 of your affidavit, you explain that you are a senior counsel, a former special director of prosecutions. And therefore, the question that I pose, Mr. Ackerman, is that as a special director of public prosecutions, you are bound, or you were then bound, by the sections that we dealt with, you and I, Section 179 of the Constitution and Section 22 of the NPA Act. Is that correct?
Yeah, unless I make a start of it, I'll accept that. But the last section you gave me to read has got nothing to do. The rest is about the conduct of prosecutors. So it doesn't make sense to me.
Even if it doesn't make sense, Mr. Ackerman, the point that I'm making to you is that when you were appointed by the president, you bound yourself to the provisions of the Constitution and the NPA Act.
That is correct.
Thank you. And you accepted that the national director had specific powers and obligations that you were obliged to respect.
I'll accept that.
And that the minister, in terms of the very same provisions of 179 and 22, also had obligations that were granted or imposed on her.
That's correct.
Now, can I take you to your evidence with respect to Dr. Ramaite? Where we start off by saying you told this commission on the 5th of March that you read Dr. Ramaite's interaction with Advocate Semenya relating to the consultation of Ramaite and Semenya. Is that correct?
Just repeat that, clearly.
When you gave evidence before this commission, you pointed out that you had read what Mr. Semenya and Dr. Ramaite spoke about in their consultation.
Oh, yes, I'm not thinking of someone else here. The evidence leader, yeah, that's correct.
Yes, that you knew when you came here that what Mr. Semenya and Mr. Ramaite discussed in their consultation.
Yeah.
And I point this out to you because if you go to your affidavit of 2015, and when you talk about political interference, paragraph 32 thereof, you talk about the first act of political interference, and you talk about the fact that there was you don't mention names in that paragraph.
Is that paragraph 32?
Paragraph 32 of your affidavit.
Yes.
You don't mention who and how. Is that correct?
That's correct.
And then when you give evidence, you talk about the telephone call between Dr. Ramaite and the minister. Is that correct?
Let me see. Is that the next page?
No. I'm not asking you about that. I'm asking about your evidence. You talk about you tell us you know that the minister telephoned Dr. Ramaite.
That's correct.
You did not speak to the minister.
No, I didn't.
You did not know the content or context of that telephone call.
Only the contents as conveyed to me by Dr. Ramaite.
Yes. If I may take you, Mr. Ackerman, to the evidence of Mr. Piccoli when he, may I start off by saying that you do know that Mr. Piccoli was the DG of the Department of Justice before he came to the NDPP.
Yes, I know that.
And I beg your pardon, Chair, is the evidence of Mr. Nguka. Mr. Nguka told this commission, and if you recall, it's Mr. Nguka as the NDPP and Mr. Piccoli as the national, as the DG.
It's correct.
Mr. Nguka tells the commission that, I'm still looking for the extract. Mr. Nguka tells the commission that he was invited by Mr. Piccoli to a meeting under the auspices of Mr. Piccoli being the DG, to a meeting. If I may read that transcript to you. It is at page 43 of the transcript. And it is Mr. Nguka's evidence.
Just read it to me and I'll
You,
reply.
Thank you. He says, no attempts during my time, nobody tried to do anything, but I will skip that. And then he says, but what I can say then say, and probably we're going to get to it. We were invited into a meeting that was convened by the Director General of the Department of Justice to look into amending the prosecutorial policy insofar as it deals with TRC matters. Did you hear that, Mr.
I hear
Ackerman?
that, yes, yes. I follow
That
you,
is,
yes.
that is Mr. Piccoli.
Senguka.
Mr. Nguka talking about Mr. Piccoli looking at changing the prosecutorial policy.
That's correct.
The moratorium comes in, or the telephone call from the minister occurs in 2004, before Mr. Piccoli gets to the office of the NDPP. You agree to that?
Well, that's when it occurred. That's
Yes.
probably.
So,
Yeah, but I know it was. Yeah.
And in February 2005, when Mr. Piccoli starts at the NDPP, he has already started a process into looking at that prosecution policy. Would that be correct? If you recall, he
I don't
started.
know about that.
You will not dispute that.
July 2005 he started.
You will not dispute the evidence that says Mr. Nguka and Mr. Nguka was invited to a meeting by Mr. Piccoli.
I don't know anything about that.
You will not dispute that when Mr. Piccoli came in as an NDPP, he proceeded to look at amending the policy, as he was entitled to do.
Is that July 2005?
I said he started work in February 2005.
Yeah, that's correct.
And he continued with the work of looking at amending the policy.
I hear you.
Mr. Piccoli was asked a few questions by Mr. Semenya. Do you know of the questions that Mr. Piccoli was asked?
Yeah, I know of it. I heard him.
The questions came on the 13th of March 2026, and I refer you and the Honorable Commission to page 176 of those questions. And it's at if I start at line, at page 176, line 7, where Mr. Semenya says, and it may be open for arguments to others to say that these, and they're talking about the policies and finding a way of looking at amending of policies. And he says, these were efforts intended to widen the ambit of opportunities to reconcile the reconciliation effort. Am I right, asks Mr. Semenya? And Mr. Piccoli answers, that is correct, commissioners, as opposed to efforts at stopping the work of the NPA. Am I right? Mr. Piccoli answers, you are right. It could not have been, an attempt to stop the work of the NPA. And that is the
He starts off by saying, and it may be open for argument to say, no, he knows it is open for argument because reconciliation at that stage does not come into the picture. Reconciliation was not an object of any structure after, what will it be, 15th of May 2020, what was it, 2003. So, you're talking about And Mr. Semenya sees the problem when he says it may be open for argument, because at that stage, reconciliation is not relevant.
Mr. Ackerman, Mr. Piccoli is the man empowered by the Act, amongst others, to look at the policies, not alone, but with the help of his prosecutors and deputy NDPPs. He's the one who's responsible for making policy, right?
Yes, but I say it's unconstitutional to take reconciliation.
I didn't ask you about reconciliation. I asked you the fact that Mr. Piccoli had the powers to look at policies, amending them, improving them. He had that power.
He has a power to amend it to constitutional policies. He can't do anything that's unconstitutional.
That is correct, but he has the power. And my question is,
Yes.
he has the power, and he says, whilst exercising that power, it could not have been an attempt to stop the work of the NPA. That's what Mr. Piccoli says.
I hear what he's saying.
Thank you. So, if we move on, Mr. Ackerman, I want us to move to your evidence about the meeting in Cape Town. You remember, Mr. Ramaite gave evidence about the meeting in Cape Town. I don't think you were there.
No, I was not.
But you do say in the transcript.
The meeting in Cape Town, what was the date?
It was the transcript is the 4th of March 2026 at page 52, lines 18 to 17. We will look at the date. And we're talking really in respect of the memo that you penned to Mr. Piccoli dated the 16th of May 2006. And then in the transcript you say, shortly thereafter, Dr. Ramaite informed you that he had attended a meeting in Cape Town. I will not read the whole transcript, Mr. Ackerman, it is long.
Yeah, I know what it says.
You know what it says?
Yeah.
Okay, thank you. So I can ask you questions relating to that meeting.
Correct.
You've already said you were not at the meeting.
No, I'm not there.
You already, and you would admit that you did not meet with the minister. You yourself.
No, No, I haven't met the minister there.
And if you look at what Dr. Ramaite reported to you about the meeting, the meeting asked of Dr. Ramaite to obtain a briefing on progress.
Now, what I read is what he attended the meeting, and he further informed me that Commissioner Selebe had alleged that the NPA was planning to paralyze government by arresting a large number of prominent government officials who had previously been involved in MK activities.
And then there was a request for a report, which you then...
I don't know if there was a...
You prepared a memo for assisted, if I may finish, in the transcript at page 12, lines 4 to 12, you state that you assisted Dr. Ramaite and you prepared a memo for the minister. stating the correct position. You did not do that.
Yes, do we have that memo?
I will go to the transcript and not to the memo. And if we go to the transcript of the 6th of March,
Yes, I'm there.
yes, you say they informed me that it had been alleged by the National Commissioner that the PSCLU was in possession of 400 dockets and planned to paralyze the government by arresting key government officials. That really was the subtext of this memo. Is that
I haven't got
correct?
the memo in front of me, so I don't know, but you probably are right. I don't see.
And then it says, or you say, I was required to assist Dr. Ramaite to compile a lengthy memorandum to the Minister of Justice, Bridget Mabandla,
I'm
stating...
sorry to interrupt my learned friend, but we don't know where she is. If she could just indicate whether she's in the memo or the transcript.
It's day
And if
6.
she's referring to
She is in
memo,
the
could she
transcript,
refer
Mr.
us to
Vani.
the record?
Am I correct, Ms. Moroka, that you are in the transcript?
I am in the transcript.
Yes. And the reference to the memo, I think it would be helpful to the witness if we got a reference to that one.
I'm reading the transcript, the evidence of Mr. Ackerman.
Yes.
Could we have a page number, please?
It is
The
page...
page.
Mr. Ackerman? I thought you were saying something.
Yes, I'm on a page where I state, and I think you referred to that, is they informed me that it had been alleged by National Commissioner that the PCLU was in possession of 400 dockets and planned to paralyze government by arresting key government officials who had been part of the ANC liberation movement. The allegation was not true, but as a consequence, I was required to assist Dr. Ramaite to compile a lengthy memorandum to the Minister of Justice, Bridget Mbandla, stating that correct position and again confirming that there was no investigation against the ANC leadership. Then I see there's a document.
Thank you.
Is
That is the extract I sought. I'm assuming my learned friend has found it. So you compiled a memo to the minister stating the correct position. Am I correct? That's what you say.
You know, I'm not too sure whether I compiled it or Chris and I compiled it, but if I can have a look at the memo, if there are long paragraphs, I will know it's Chris McAdam. If it's just short paragraphs, I will know it's mine.
Do you disagree with this memo?
Let me see the memo, please.
I haven't got the memo in front of me, Mr. Ackerman.
With
But I'm
respect,
talking-
Chairperson, that's an unfair question because the witness simply doesn't have the memo before him.
Yes, Ms. Moroka?
Chair, I can find the
Does-
memo, but
Does
this
he
is his
disagree
evidence.
with the memo of what? Or does he disagree with the fact that he prepared a memo?
I am merely talking about relating to the evidence that he gave, Chair.
Yes.
If my learned friend wants the memo, I look for the memo. I don't have the memo in front of me. I'm talking to his evidence.
Yes. And what do you say about the memo with regard to his evidence?
I say nothing about the memo. I
Yeah.
say this is what you said in your evidence.
Yeah.
And am I to understand that you're saying you did not compile the memo?
Show me the memo and I will have a look. You must understand that Dr. Ramahiti is sitting there, he asked me for information. I will give him the information, or he will ask me, can you just give me a short draft on the matter, and then his secretary might type it. But it is, I assisted him, or Chris assisted him in drafting a memo. I don't think my name appears anywhere on that memo if it's to the minister.
Can I be helpful, Mr. Ackerman? I do not want us to go into the content of the memo. What I want to find out from you is there was nothing untoward in writing or preparing a memo for the minister and the minister asking for a memo about these events. Is there anything untoward about that? The law gives her the right to ask for reports, and she was being given a report. Anything wrong with that?
It's good. No, no.
Thank you. Can we then go to the meeting with the minister of 2007? And for that meeting, if I could ask you to look at the transcript of the 6th of March. And I refer you to page 53.
Yes, I see that.
Sorry, Mr. Ackerman, our musical chairs here with the recording. You see, you are there.
Yes.
It is at line 10.
Yes.
And we confirm that you went to this meeting with Mr. Ramaite.
That's correct.
Can I just understand one small thing? In your evidence under cross-examination by Mr. Masuku, you said you'd never ever met Mr. Simelane or discussed the TRC cases with Mr. Simelane. Or
You
is
say
my...
I said that? I'll accept that.
But Mr.
Okay, just a
Simelane...
question. What did I say?
You were asked whether you'd met Mr. Simelane or whether you had spoken to him about TRC cases. You talked about the peace pipe incident.
Yeah.
Do you remember that?
Yeah, he was at that stage when I hear what you're saying, that I then, in fact, did speak to him about the TRC matters when he was a director general, not the national director of prosecutions.
So you did speak to him when he was in the DGs, as a DG?
Well, the record shows it.
Well, if I take you then to your transcript of the cross-examination by Mr. Masuku, and this is transcript on the 19th of March, page 6, line 21, page 8, and page 8.
Yes. You know, you can read it down to me and I can confirm
Okay,
it.
yeah.
I'm not satisfied.
It says, okay, but you have never spoken to Mr. Simelane about the TRC cases at all. And your answer is, I do not think so.
Yes, but that is in the context when he was the director, when he was the national director of prosecutions. We never spoke about any TRC matter, as far as I can recall.
But if I move on, and then there's a question from Mr. Masuku that says, so on either timelines, your answer is that you have never spoken to Advocate Simelane, either as DG or the NDPP, on any cases that involved the TRC. And your answer is...
Correct.
Just wait for the question to be completed, Advocate Ackerman, before you respond.
The answer is no, if you give me the facts to refresh my memory, I might say yes.
Well, there I said that. I asked him the question. No, if you give me the facts to refresh my memory, I might say yes. What I was meaning, I didn't think of the meeting I had with him in his office in Pretoria, in the minister's office.
Thank you. I just wanted to understand that, but because it seemed contradictory. So if we go to the meeting with the minister, Mr. Ackerman, you say that the meeting with the minister was on the back of a memorandum that Mr. Piccoli had sent to the minister on the 10th of July, 2007.
That's correct.
Now, to be clear, this memorandum that Mr. Piccoli sent to the minister informing her that the case had been set down for hearing in court on the 17th of August, 2007, and that all accused will plead guilty to the charge of attempting to murder the Reverend. So this was an information memo, would I be correct?
That's correct.
And it followed several months of negotiations between the PLC, PCLU, and the attorneys for the accused.
That's correct.
And the minister was not involved, and the minister did not know about the negotiations, nor about this case.
I don't know what she knew.
Apologies, Chair.
Saying
There's a call from the head of security.
Where do you get that from, Ms. Morocco?
On my screen. What am I to do with it? Head of security sounds serious. Am I to ignore it, Chair?
Are you suggesting that we adjourn?
No, I don't know, Chair. I was asking, there was a call.
Yes.
And head of
No,
security is,
we'll ignore it until it's brought to our attention.
we ignore it until the bomb threat goes away, Chair.
Yes.
Okay, thank you. So, Mr. Ackerman, at that meeting, the minister is surprised at about events that are happening because she had a firm impression that there were no TRC prosecutions. Is that correct?
Yes, I was surprised too that he did say that.
So, if one has a look at your transcript and the interaction between yourselves and the minister, at no stage did the minister say, stop the prosecutions. Did she?
Which prosecution? She can't imagine.
No, TRC prosecutions. Because she's talking about prosecutions of TRC cases. My question is, at no stage did she say, stop these prosecutions?
No, she said she was of the firm impression that there were not going to be prosecutions. That's what she stated.
Can you then answer the question after saying that, Mr. Ackerman?
She didn't stop it. She was not aware of any prosecution.
The question is, the minister did not say stop prosecutions.
No,
She did not ask you to stop prosecutions.
No.
There was nothing unlawful about her asking what is going on.
No.
The guidelines had been implemented and had been set aside. Would I be correct? I'm not sure about the timeline. But they were
I don't think
implemented
they've been set aside
then. So I reiterate, she did not say stop prosecutions at that meeting.
No.
Now, in your evidence on the 19th of March, if I go to The transcript, page 12.
At page 12.
12. You say, I am of the view there was a common purpose amongst Mr. Silebi, Mr. Simelani, the minister, the cluster ministers, to get rid of me. If you do not agree with that, say, I do not agree. And then Mr. Masuku then answers and tells you he's not under cross-examination. Do you recall that?
Well, I read it.
And Mr. Masuku then asks you for evidence about Mr. Simelani attempting to get rid of you. Do you recall
Where is that? Give me the page number.
We will get back to it. We're looking for the transcript. The question that I seek to ask is, you're not accusing the minister of being a party to hacking your computer, are you?
No, I don't think she's got the know-how.
Well, yes, you do seem to have a dim view of her and an elevated view of yourself, Mr. Ackerman. And you do not accuse the minister of being involved in the alleged forgery, do you?
You asked me, I don't think she was not involved. She might have joined it later on when she realized it's forged. I don't know what the position is.
I didn't get
It is a forged letter. She had the letter in her possession.
The question that I'm asking, one, is that she was not party to being a party to hacking your computer or the alleged forgery. That's all I'm asking you.
No, she was not involved with the forgery.
And
I wouldn't think so.
There is no evidence before this commission accusing the minister of having a common purpose to get rid of you.
Well, if you look, it's a long answer I can give you. She was a member of the committee of ministers where it was openly discussed that they must get rid of me. I mean, if it's disputed, then Mr. Simelani is not telling the truth, because he said the minister was present when all commissars and commanders gave evidence that Mr. Piccoli must get rid of me.
The minister was present where?
It was a meeting. I don't know if it's a meeting there were many meetings where she was present, where my removal of TRC cases was discussed.
You were not in any of those meetings?
No.
You have no independent evidence that the minister was there?
If you say independent, I have Mr. Simelani's evidence and I have Mr. Piccoli's evidence.
About the minister?
Yes.
Saying they must get rid of you?
No, what I have is there was a meeting, let's say in the West Wing, we don't have dates, where a minister was present, where my removal was discussed. It was, in fact, the only point on the agenda was my removal.
We don't have that evidence in this commission, Mr. Ackerman.
Well, Mr. Piccoli gave evidence to that effect, and Mr. Simelani.
That there was a meeting where your removal was discussed with the minister. You said nothing about that here.
No, she was present. All the ministers were there, including Minister Mbandla.
He is putting it at a high cloud.
Mr. Mshe has given evidence about how it came about that he removed you from the TRC, specifically from the dealing with TRC cases. You remember that?
Yes, I remember that.
You remember that he says that it was his decision and not the ministers nor Mr. Simelani's.
Yes, that's his evidence.
And he told this commission why he thought it was appropriate that he should remove you as a member dealing, or as the head dealing with the TRC cases.
Yes, because Mr. Reverend Chakani complained. It was not about all the complainants by all the ministers and the ministerial committee and the directors general. It was because Reverend Chakani complained.
And that is Mr. Mche's evidence.
That's his evidence.
Thank you, Chair.
Thank you, Ms. Moroka. Thank you. Mr. Vani?
Switch off the mic.
No, we'll take at 11.
Chair, I see that we have been going for an hour and a half. Can we just check
Yes.
with Mr. Ackerman if he wants a short break?
Mr. Ackerman, would you like to take a short adjournment now or at 11 o'clock?
Let's do it at 11 o'clock.
Thank you, Mr. Ackerman. Yes, Mr. Vani?
Mr. Ackerman, at the beginning of your cross-examination by my learned friend for the minister, the various sections of the Constitution and the MPA Act were put to you. Although one particular section was not put to you, which I will do so now, it's section 32(1)(b) of the NPA Act. It reads as follows. Just to save time, I'm not going to ask you to find it. I'm going to read it into the record. Subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state nor any other person shall improperly interfere with, hinder or obstruct the prosecuting authority or any member thereof in the exercise, carrying out or performance of its, his or her powers, duties and functions.
Yes.
You're familiar with that section?
Yes.
In your view, the actions of Minister Mbandla, do you believe that her conduct in relation to the TRC cases was inconsistent with this section?
Yeah, it's improperly to stop a prosecution is at least some offense. You can't intervene with the decisions of the national director or any prosecutor.
And
She hindered prosecuting the matter.
and directing the acting NDPP to suspend work on the TRC cases pending the formulation of guidelines, which, as you've said, resulted in the suspension, at least for 2 years, would that have been an improper interference with the work and discretion of the NPA?
Correct.
I want to refer you to the evidence of former NDPP in Guka, his transcript at page 43, line 20. This is his evidence before this commission on the 2nd of March 2026. And my learned friend referred you to this page during cross-examination. Perhaps just to save time, I'm going to read the passages to you. My office, and by way of context, this was the request to the NDPP to send representatives to a meeting convened by the Director General of the Department of Justice to look into amending the prosecution policy insofar as the TRC matters were concerned. It reads as follows. My office was represented then by one of my advisors, Lungisa Kosi, and another guy called Gerard Nel. Gerard's Nel responsibility in my office was to prepare legislation that had to go to Parliament. He was specializing, he was drafting legislation. We discovered early on that it is important for us as the NPA, if any legislation to be passed, that we are consulted and that we contribute to it. And so we created that capacity in my office. And then the next page, 44. So Gerard and Lungisa went to that meeting and they came back and reported to me what had transpired in the meeting. And in their view, which I accepted, was that there was no need for us to participate in that forum and that there was no need for us to change the prosecutorial guidelines that we had, and that is it. Were you aware that the then NDPP, Advocate Bulalani Ngruka, declined to allow NPA representatives to be involved at that point in time in reformulating the prosecution policy insofar as it impacted the TRC cases?
I did not know anything about these new TRC amended policy. I didn't know of it. It was not discussed with me.
And it was put to you by my learned friend that in relation to your interactions with Minister Mabandla, she put it to you that at no stage did she actually say in blunt terms, stop the prosecutions, and you confirmed that was so. But I want to revisit the transcript of the 6th of March at page 54. And your recollection of that meeting, you stated that she indicated, and I underline the words, it was her firm impression that there were not going to be TRC prosecutions. And then when you advised her that at least one was going ahead, namely the Chikani prosecution, she asked why she had not been informed of it. You then pointed out that she had been informed previously. Now, I want to put it to you that, without mincing words, although she didn't say stop the prosecutions, the fact that she said that she had a firm impression that they were not going to go ahead, what did that say to you?
That somebody told her that there were not going to be prosecutions. And she believed that. And I found it very strange because he was sitting in a parliament when the president on the 15th of April 2003 delivered his speech regarding TRC prosecutions, clearly stating that there will be no amnesty and the prosecutions will proceed. That's why I also think that because of the Petco matter, he was not interested in having reconvene an amnesty meeting, because she knew that she was of the opinion then that there were not going to be any prosecutions. I think that's the reason why the Petco matter never went forward.
No further questions.
Thank you, Mr. Vani. Mr. Soni?
Good morning, Mr. Ackerman.
Morning.
Mr. Ackerman, can I just refer to a few milestones in respect of your involvement with the TRC matters? It is correct that you were appointed as the head of the PCLU in March 2003, is that correct?
Yeah, that's correct.
And in October 2003, the NDPP directed that the PCLU must assume responsibility for the investigation and presentation of all cases emanating from the TRC. Is that correct?
It must have been somewhere in May 2003.
Right. I just want to, I don't think it matters, but just so that the commissioners have a reference to it, I'm going to refer you to Kalata Group Volume 3, Additional Bundle 3, relating to yourself. And on page 1 of that bundle, there is a letter from the NDP, or a note from the NDPP, which says, and is dated the 21st of October 2003, says, in terms of the powers given to me under the Presidential Proclamation of the 24th of March 2003, I hereby direct that your unit assumes responsibility for the investigation and prosecution of all cases emanating from the Truth and Reconciliation Commission. Are you prepared to accept that, Mr. Ackerman?
Yeah, I accept that.
Then, Mr. Ackerman, and you've recounted this, soon after Mr. Piccoli, Advocate Piccoli, was suspended in around September or thereafter 2007, you were relieved of your duties in relation to TRC matters. You've given evidence about that.
That's correct.
And you did say, though, that although you were not in control of those matters, you did keep up to date with what was happening in those matters.
That's correct. I had to manage it.
Yes.
Certain concerns.
And then you retired on the 31st of March 2013. So you are no longer and have not been with the NPA for about 13 years now. Is that correct?
That's correct.
Now, when you were appointed, as has been indicated by those milestones I've read out to you, you actually needed to work out how to deal with TRC matters. Is that correct?
Can you just repeat the question?
I say you were now in charge of an important area of prosecution, of possible prosecutions, and you needed to develop a policy in regard to how you would execute that mandate. Is that correct?
No, I didn't form a policy. But the closest we can come to a policy is when Chris McAdam wrote on the 3rd of May, I think, or maybe even earlier, 2003, are we going to approach these prosecutions? And more of the cases that we had at that stage.
Yeah. Mr. Ackerman, it's going to be a lot easier. I am asking specific questions. You just answer the questions. If you want to then add something to it, perhaps you could use the opportunity in re-examination. But I would just like to you to focus on the questions I ask, if you don't mind, please.
Yeah, but I was under the impression that there was a policy drafted. There was no policy.
Can I then refer you to, Mr. Ackerman, a document that was submitted to Dr. Ramaite, seemingly from yourself, and I say seemingly because I understand that sometimes Mr. McAdam drew up documents, but it doesn't matter. Just want to look at the contents of the document. It is a memo that that is dated the 24th of October 2006, and the subject matter is audit of cases emanating from the TRC process. Commissioners, that appears... Sorry, Mr. Ackerman, I've not asked a question. I'm just referring you to it, and I'm going to tell you where you find it. Commissioners, that appears as PCJ 5 in the Jacobs bundle, and it's page 1723 of that bundle. Page? 1723. Mr. Ackerman, are you able to access that document?
I have it in front of me.
Good, okay. Now, in paragraph 1, which starts at page 1723, you trace the historical background to the TRC case, TRC process or cases. And I want to deal firstly with paragraph 1.9 on page 1724. Are you there?
I'm there.
So, having traced the historical development that took place in regard to TRC matters, dealing with the D'Oliveira Commission or the D'Oliveira unit, and how the cases were divided between the DSO and the police, at paragraph 1.9, you point out that no prosecutions were instituted because the TRC's final report and the President's response thereto were outstanding.
Yes.
And that must be correct. Is that right?
That's correct.
Yes. Then you say in paragraph 1.10, with the creation of the PCLU in March 2003, the NDPP assigned all TRC matters to it after the TRC had tabled its final report, and the President had mandated the NDPP to institute prosecutions where appropriate arising from the TRC process. That's correct as well, am I right?
Correct.
Okay. Can I just say, in relation to this TRC report, in relation to prosecutions, is a passage in that report which has a bearing on the manner in which its report was to be implemented. And it's at paragraph 24 of volume 6. I'm just reading to you the relevant part of that paragraph. And it's also contained in the Rodriguez report, where what the Commission said is it has always been understood that where amnesty has not been applied for, it is incumbent on the present state to have a bold prosecution policy in order to avoid any suggestion of impunity or of contravening its obligations in terms of international law. Now, that's what I'm just reading to you what that part of the Commission's report said.
Yes.
And in a sense, that's what the President, as you point out in 1.10, said, that these cases must now be prosecuted. In other words, the TRC cases must now be prosecuted.
Correct.
Now, you then say at paragraph 1.11, the PCLU was not an investigative agency and was therefore dependent on SAPS and the DSO for investigators.
Correct.
Now, just if I could comment on this, one of the themes that appears over and over again is seemingly a dispute about where the PCLU should source investigators for the TRC cases. Should it be from SAPS or should it be from the DSO?
Correct.
Okay. Now, one of the first matters that, one of the first issues that arises in that case seemingly is a letter. And Mr. Ackerman, can I say to you, I'm going to read to you parts of a letter written by Commissioner De Beer. It appears at page 296 of Kalata Bundle 1. It is... sorry, are you familiar with it?
Yeah, I'm familiar with it.
Okay, I'll just read it to you. You don't need to go there. It's a letter dated the 26th of September 2003, and it's addressed to yourself, and it comes from Divisional Commissioner De Beer. So I understand it, Mr. Ackerman, and I just don't want us to have disputes about what Mr. De Beer's role is. Mr. Commissioner Jacobs, when he gave evidence, says that in regard to operational matters, Commissioner De Beers was the person at head office to be contacted. Are you prepared to accept that?
That's correct.
Okay. Now, coming back to the letter, he says to you, Dear Advocate Ackerman, investigation of TRC cases. And he says your letter dated the 20th of August, as well as the preceding discussion between ourselves, have referenced. And then he says at paragraph 2, as agreed at our meeting, I have discussed your request for the assistance of the South African Police Service to investigate cases emanating from the TRC processes with the National Commissioner. That, of course, is Commissioner, the late Commissioner Celebi. Would that be correct?
Correct. Correct.
And then he says, it is evident from your letter that the investigation and prosecution of these cases were referred to the NDPP by the President. You accept that, that's what the position was?
That's correct.
Okay. Now, he then says, and I want to emphasize this point, our understanding was that this referral was politically inspired. That's the version, or that's the approach adopted by Commissioner De Beer, certainly, and I don't know whether it's the rest of the police, but that certainly was his approach as reflected in this letter. Would I be correct?
That's correct. That's correct.
And then he says, as you know, a large number of cases to be investigated are those of ex-policemen. And that must be correct because numerous, in fact countless, complaints had been made about abuses during the apartheid regime by both the police and the army. But he is now dealing with the police. That be correct?
That's correct.
Therefore, he says then, because these involve ex-policemen, it is therefore understandable that you first endeavored to have these cases investigated by the Directorate of Special Operations, that's the DSO. Is that correct?
You say that my first endeavor was to have the cases investigated by the DSO. Let me think. That sounds fair. I think it's correct.
Okay. Then he goes on to say, from your letter, it is, and I just want to point out as context to the rest of the letter, the point I made to you that there was a concern that the, if I could put it, the old order policemen were going to be investigating themselves. That's the context from the second paragraph of the letter. Then in that context he says, from your letter, it is firstly not clear why the DSO do not have the legal mandate to investigate the cases emanating from the TRC, and secondly, why it was not possible to obtain a presidential proclamation to provide such mandate if it was lacking. Your letter only states that in March 2002, consideration was given to the issue of a presidential proclamation, but problems were encountered in this regard. Chairperson, I see it's 11. May I finish this letter
Yes.
so we don't have an
Yes,
interruption of it?
you may.
I'm indebted to you, Chairperson. And Mr. Ackerman, I take it that's okay with you. I won't be more than a few
That's
minutes.
fine.
And then you say, Commissioner De Beer say, as you are aware, you are aware of the fact that the capacity created by for the D'Oliveira Committee is presently with the DSO. Then he goes on to say, in view of the nature of the investigations, and it's obviously relating to the fact that it involves ex-policemen, the fact that the President had referred it to the National Director, and that it seems to be common cause that the initial understanding was that the DSO would have to investigate. The opinion is held that you or the National Director should approach the President and confirm the instruction of the President on who he wants to investigate these matters. And finally, he says, if the President indicates that the police should be involved in the investigation, the instruction should be obtained in writing. Upon receipt of such instruction, the South African Police Service shall of course assist, and the terms of reference, as well as the issues such as logistics, number of investigators, command, can be discussed, as well as other relevant issues. Then he concludes to say, you are therefore requested to approach the President on the matter, whereafter we can take the matter further if necessary. And he signs off with kind regards. That's Commissioner De Beer's letter to you on the 6th of September 2003, following a request from you on the 20th of August 2003. Is that correct?
That's correct.
Chairperson, I want to comment on the letter and so on, but it may take a bit of time.
Yes.
If I'll await your directions as to
Yes,
whether
I
you-
think this would be an appropriate time to adjourn for tea and reconvene at 11:15.
As you please, Chairperson.
Mr. Sonny?
Thank you so much, Chairperson. Now, Mr. Ackerman, are you there?
I'm here.
Yes. So, Ackerman, can I just make a point about a point that emerges from Commissioner De Beer's letter? What is quite clear is that the police appear to express a reluctance to investigate their own, if I can put it that way. Would that be a fair reflection of what Commissioner De Beer says?
Can you just repeat that day?
The police expressed a reluctance to investigate their own.
There appears, yes.
Yes, that's correct.
Well, that's I say, is one of the themes that appears to emerge from this letter.
Yes,
Okay.
I agree with it. Perhaps just the perception that they are.
Well, I'm only telling you what the letter says. We don't know
Yes,
what's in
no, I
their mind.
agree. I agree.
And one of the themes is, if you want to investigate the alleged perpetrators of human rights violations by the apartheid state, ask the DSO to do so.
Yes?
Now, can I then ask you, Mr. Ackerman, do you have bundle 18, which contains the statement that Advocate Ledwaba made to the made in preparation for his evidence to the Commission earlier this week? You have that with you?
No, Mr. Fenter will for me.
Okay. When you do, please let me know.
I have it.
Okay. Now, can I ask you, before I go to the statement itself, Mr. Ledwaba was the director in the DSO, is that right?
That's correct.
And if investigators were to be sourced from the DSO, it would be through Mr. Ledwaba.
That's correct.
Right. Now, in paragraph 61 of his statement, he says, in May 2003, Advocate McAdam, in his capacity as Deputy Director in the PCLU, filed applications at my office requesting that I declare certain TRC cases as projects under Section 21A of the NPA Act, 28 subsection 1A of the NPA Act, in order for TRC cases to be investigated for the DSO.
That's correct.
Okay. And his response to you, and we don't have to go into this in detail, his response is that such a request fell outside his mandate, and that if you wanted to source investigators from the DSO, you needed to do it via Section 28(1)B of the NPA Act. That was his response. Is that correct?
That's what he says.
Yes, no, I understand. And I know you disagree with him, but I'm just trying to reflect on the developments that took place. Then in paragraph 63, he says, on the 15th of July 2003, yourself and Mr. McAdam held a meeting where a similar request was made that he utilizes his powers under Section 28(1)(a) of the NPA Act. Is that correct?
Is that are you reading from paragraph 63?
63, yes.
But there's nothing about which section he's using.
Could it be any other section, Mr. Ackerman?
Can be 28(1)(b).
But he is not the NDPP. Mr. Ackerman, let us take this seriously, please.
Taking exception to that.
Mr. Ackerman, can I then say to you that at paragraph 64 he says, to you and Mr. McAdam, that he's unable to assist?
Yes.
Then he goes on at paragraph 68 to say, it is unfortunate that Mr. Ackerman and McAdam did not follow my advice. He says in December 2003, however, it appears that the penny finally dropped and they did approach the NDPP, that was then Mr. Nguka, in terms of Section 28(1)(b). That did happen, is that correct?
I disagree with what he's saying. At no stage did he have any objection about which section we're using. He said he's not going to investigate any TRC matter. If I may have a look at my memo 11 November 2003, at no stage did he say he is not investigating because the wrong section is used. And Mr. McAdam will be able to give evidence on that. As I know Mr. McAdam, being a very competent advocate, he will know exactly how it is done.
Yes.
So the point I'm making, at no stage was he telling us he's not investigating because we're not using the correct section.
I understand perfectly. Can I just put the dispute in context then? Your dispute is not that you did not approach him. Your dispute is not that that he said he couldn't help. Your dispute is he said he will not help. Is that correct?
That's correct.
Okay. But let's then just go on to what happens next. He says, and I want to take us to paragraph 78. And mindful of the dispute you raised with what Advocate Ledwaba says, he says at paragraph 28, the NDPP, this is the second sentence in paragraph 78, the NDPP approved a request made to him and signed a directive instructing Mr. Ledwaba to authorize the four matters in terms of Section 28(1)(b) on the 24th of February 2004. Now, is it correct that Advocate Nguka did authorize the use of Section 28(1)(b)?
Yes, I think what happened is that we forced the Dwaba now to investigate. But Chris McAdam will be able to give evidence on that point. I'm not afraid, I can't recall precisely why we use 28(1)B at a later stage.
Mr. Advocate Ackerman, I do not intend to be short, but I do want to say I'm simply trying to get to the thrust of the matter. And the only question is, did Advocate Nguka authorize the investigations?
Yes, I know there was authorization.
Okay. Now, can I ask you to look to the second last page of that bundle, and it's page 1745, and you'll see there's an internal memorandum addressed to Mr. Ledwaba in his capacity as Head of Operations of DSO, and it's dated the 8th of December 2003. It emanates from the NDPP, and he says on the subject, investigation of TRC cases by the DSO, he says, I've decided in terms of Section 28(1)B of the NPA Act that the following 3 cases arising from the TRC be investigated by the DSO, but he goes on to mention 4 cases, and you accept that those are the 4 cases that were authorized to be investigated by the DSO.
That's correct.
And this authorization was signed by Advocate Ledwaba on the 24th of February 2004.
Yes.
Right. So you were granted DSO investigators in terms of this.
That's correct.
Okay. Then can I go back then to paragraph 79, or not back to, but go to the affidavit and now refer to paragraph 79 of the affidavit. This is the fact that Advocate Nguka had authorized a further 3 matters to be investigated by the DSO, and Advocate Ledwaba says that he complied with a directive by the NDPP and allowed another. He then allowed at page 81 a further 3 matters to be investigated by the DSO. You see that?
Is that paragraph 81?
Paragraph 81. That on a further request by the PCLU, 3 further matters were authorized.
Yes, I see that.
And if you turn to the last page of that bundle, you'll see that it's 2 further matters, and they are named in MGL 5, which is the last page of that bundle. And that is, again, from the office of the NDPP to Mr. Ledwaba, saying that he's decided to refer the following matters to the DSO for investigation. And the 2 matters are the Upper attacks on the St. James Church and the Heidelberg Tavern situated in Cape Town. Do you see that?
I see that.
Right. So we know now that there were 6 matters that were authorized by the NDPP to be authorized to be investigated by the DSO.
That's correct.
Now, can I just ask you, you made an affidavit, and it's been referred to on several occasions, the last occasion by my learned friend, Ms. Meroka, this morning, where reference was made to the affidavit you filed in the Kadimeng 2 matter in 2015. You remember that?
Yes.
Now, can I ask you, in that matter, you indicate at paragraph 16, and we are now talking about 2015, you say at paragraph 16, where you indicate that the progress of cases has not been good in respect of TRC matters. Then you say, identifying the matters that where investigations or the cases had been finalized, you say, in relation to post-TRC prosecutions conducted by the PCLU, only the following cases have been instituted. The cases are State versus De Blanche, State versus Blarney, and State versus Nieuwhout. And just to put it in context, that is the case involving the PEPCO 3. Would I be correct?
That's correct.
Then you'll see that you describe at paragraph 16.1 what happened in the De Blanche matter, and you say that in 2003, the former leader of the AWB, who had been charged with various acts of terrorism during the 1990s, entered into a plea agreement with the PCLU in terms of Section 105A of the Criminal Procedure Act. And that is what happened. Is that correct?
That's correct.
That's one of the cases you referred to as having been finalized by the PCLU.
That's correct.
And then in paragraph 16.2, dealing with the Blarney matter, you point out that Mr. Blarney, an ANC member who had been implicated in the mob killing of two persons, hadn't applied for amnesty. The matter was fully investigated. He was arrested, and then thereafter a plea and sentence agreement was concluded, and he was convicted on all charges and sentenced to 5 years imprisonment, 4 of which was suspended for 5 years. And that happened as well, as I understand it. And that too was in terms of Section 105A of the Criminal Procedure Act.
Correct.
And then you deal with the PEPCO 3 matter, and you indicate the difficulties that arose in that matter, and it had to do with the fact that the Department of Justice had not provided for legal representations for the persons concerned, or had not paid for the legal representations, and therefore the amnesty or the review of the refusal of amnesty could not be concluded. So that matter was not concluded at that stage. Is that correct?
Correct.
Now, one of the matters that you don't mention in this case is the matter of State versus Van der Merwe and Flock and the 3 foot soldiers who were involved in the attempted murder of Reverend Chikane. But that matter had also been concluded by the time this affidavit was done. Am I correct?
I see what you're getting at, but
Now, Mr. Ackerman, I'm just trying to complete the picture so that...
Yes.
And really, with respect, I'm not getting to anything. I'm just trying to paint a picture for the position at 2015 in relation to TRC cases.
you know, paragraph 15 says during 2004 and 2005, we identified 16 cases.
No, I'm talking about,
You know,
Yes, I thought maybe you must just repeat the question to him.
yes. Mr. Ackerman, I'm just trying to deal with the cases that were completed by the PCLU as at the time you had made your affidavit in Nkadimeng 2 in 2015.
look, if you say it's the Connie matter was obviously done. I don't know why you refer that this was the stage at 2015. You know, it's the cases I refer to, like the Eugene Terblanche, Blarney, and Nivo cases. They are, I think, even before the guidelines were drafted. I'm not so sure that I refer here to after 2015. You know, I'm not sure why I don't mention Shakani here. Perhaps you can tell me what is the point you would like to make.
No, I'm just, Mr. Ackerman, if you don't see a lion behind the bush, there is no lion. I'm saying this to you that I'm just trying to work out and present to the Commission what the state of play was in respect of TRC matters at the time you signed this affidavit, according to this affidavit. And I'm just saying that when one looks at the picture as a whole, added to those three cases is obviously the case of the Chikane accused.
Commissioners, I don't wish to interfere with the cross, but just to save time, my learned friend suggests that the witness didn't mention the Chikane case in his statement. In fact, in paragraph 17, the very next paragraph, he does refer to the Chikane statement. I hope that the Chikane case.
Mr. Soni?
My learned friend must know that what is referred to in paragraph 17 is the fact that there was this alleged interference. That's not, it doesn't refer to the completed case, and my learned friend must know that, Chairperson.
Yeah.
Yeah, but
Mr. Ackerman,
yes.
you may respond to the question.
Well, I see now in paragraph 17, I mentioned the Shakani matter. And I don't, you know, I have to read through it, and I don't know whether I deal with the plea bargain and the conviction of the of the 5 people. If it's mentioned in my affidavit, that is another case that we're disposed of. That was another case that we disposed of.
And that's the reason I wanted to give us complete a picture to the Commission and to you as to what the state of play was. Now, may I come back to this point then? So as at 2015, on the basis that 4 cases were completed, you had been in charge of the PCLU by that stage at different levels, if not in charge, then certainly playing a role in the PCLU. In the period of 10 years, 4 cases had been done, had been finalized.
Yeah, the prosecution.
Yes. You accept
There
that?
were many dockets that were closed and decided on over hundreds.
And
Those are the prosecutions.
Yes. No, I understand. I'm just trying to say that effectively that's the list of cases that were completed by your unit.
Well, that's what I say in my affidavit in 2015. Was quite certain I left a lot of things out because I was not in possession of all my documents. Later on, McAdam saw some documents that I saw, documents that I didn't even know exist, letters that I've written. But on paper, it looks like those are the only 4 cases, but McAdam can rectify it if I'm wrong.
No, of course. And I'm saying to you that's particularly why I mentioned the Van der Merwe case, because I wanted to, in a sense, add to the picture you had painted because it appeared incomplete. But let's get past that point. I want to say to you, on any basis where there had been thousands of violations of human rights by the state during the period that the TRC was required to investigate. On that basis, this is, and I'll put it in neutral terms, as described by your counsel on different occasions, this record is dismal. Would you agree with that?
Yes.
Now, can I just ask
But
you...
I'm not the cause of it.
No.
Mr. Ackerman, just keep to the question that has been put to you in your response.
Thank you, Chairperson. Now, I just want to go back to your, because, and I want to be fair to you, and I'd always intended doing this, Mr. Ackerman. You referred to other matters, and these other matters are referred to in PCJ 5. This is the document I referred you to earlier this morning, which is the historical background to the or your audit of TRC cases as at 2006, because that's when the document is dated.
I'm familiar with that document.
Right. Now, in this matter, you say at paragraph 1.14, you say the PCLU conducted an audit of all the cases in both offices. And remember, the 2 offices are yourself having taken over Advocate Fick's cases and the cases that McAdam took over from the DSO. Those are the 2 offices you are talking about, is that right?
Yes.
You see that at paragraph 1.13.
And
then you say at paragraph 1.16, during 2003-2004, Advocate Ackerman declined to prosecute plus minus 80 of the above mentioned cases. Oh, sorry, I forgot to point out that in paragraph 1.15, the memo says, in this auditing process, it was established that the police officers at Fick's office at the DPP Pretoria had registered 395 police dockets. That's about, that figure is about right?
Do you want me to answer? Yes.
Yes, okay. And then it says that you declined to prosecute in plus minus 80 of the cases.
Yes.
And then it says similarly, plus minus 50 cases from the DSO were finalized by Mr. McAdam and Mr. Ackerman.
Correct.
And then you say at paragraph 1.18, the audit process further identified a small number of cases warranting prosecution which are dealt with hereunder.
Yes.
Okay. Now, then you categorize the cases into three broad groups. The first group, which is dealt with at paragraph 2, deals with the cases that were finalized in court.
Correct.
And you deal with 4 cases there.
Correct.
2 of the cases are those that were mentioned in your affidavit, and then there are 2 cases which were dealt with by by Advocate Mahaga. Am I right?
That's correct.
Okay. And then you, in the second category, you deal with the cases that were closed by the PCLU, and I count them to be 26 cases. Will you accept that for now? Because
I'll
I'm gonna
accept
come
that.
back to this. And then, Mr. Ackerman, this was the point you were making when we were dealing with your affidavit. If you look at page 1729, at paragraph 4, you identify a number of potential prosecutions that the PCLU had identified, and these total 22. We accept that?
Yes.
Okay.
Accept
Now,
that.
Mr. Ackerman, I'm only for the time being interested in the first 2 categories. Now, in regard to the first category, we know that you dealt with it in your affidavit in the Nkadimeng matter, and we now know that in addition to the 4 cases there are the 2 cases that Mr. Mahaga dealt with, so that's a total of 6 cases in all. Now,
Yes.
can I then ask you to go back to paragraph, the main paragraph 3, which were the matters that were closed by the PCLU, and I said I'd come back to that. I've said to you there are 26 cases there.
Yeah.
Just in relation to this, as I understand it, this is a report that was presented to the task team, and they asked for more details in regard to these 26 cases. Would that be correct?
I can't recall it, but if you say they did ask for what could, I'm not
They wanted
sure.
more details.
I can't hear.
Okay. Mr. Ackerman, can I ask you to go to PCJ 7 at page 1737, please?
Yes.
So you remember that we were dealing with paragraph 3 on the previous memo, which were matters closed by the PCLU, and you'll see that this is a memo prepared by yourself, addressed to Dr. Ramaite and the UCC, the NDPP, and Advocate Kalyani Pillay, and you then say that these are the details of the TRC cases closed by the PCLU. And in the first paragraph you say, on the 25th of October 2006, the PCLU was requested by the TRC committee to furnish more details regarding all the cases which the PCLU had declined to prosecute. The PCLU was also requested to furnish the background to the prosecution of one blind. And that's what this addresses, am I right?
What this?
That's what
Sorry,
this
I-
memo addresses. In other words, It's
Yes.
revisiting paragraph 2 of your previous memo.
Yes, can I just, I don't know if it's important. I, of course, didn't compile this list, the letters to October 2000, I mean, 24th of October 2006 and 30 October 2006. I think Mr. Maga said that he compiled this list. He wrote the report.
Okay, but can we accept that what's contained in here is correct because you then submitted it to the NDPP?
Yeah, as far as he checked each and every case, you know, I didn't certainly go to each case and see what the position is.
Okay. I just want to, in regard to this, and I see the qualification you make, but in regard to this, there are 3 cases that I want to look at in particular.
I'll do that.
Firstly, before I get to those 3 cases, who made the decision that these cases, the 26 cases itemized in paragraph 2, should be closed?
Yeah, I can tell you about the Timol case, but I have to go back. I just want to see in the previous matter, Marga put the names of each person who dealt with it. If you can assist me. Do you want me to start off with the Timol case?
No, Mr. Ackerman, let me ask the question, then you. I say
Yeah.
that my first question to you before I go to any particular case is this. Who took the decisions in respect of closing these cases? Were there different people involved?
That's correct.
Okay. So, paragraph 1.16 of your memo of the 24th says, and that's the reason the questions have been posed in this way, says, during 2003-2004, Ackerman declined to prosecute plus minus 80 of the above-mentioned cases. So it must then be that you and other persons from the PCLU had made that decision.
No, regarding the 80 cases, the only person who made the decision, I think, these 80 cases are the cases reflected in paragraph 1.15 that Brits then brought to me.
Okay.
So part of the 395 that was with in the DPP's office or at the later stage in the police's office.
Okay.
And those are the cases reflected on those notes that I've written in each case. I've written a note, putting it in the docket.
Those are the memos you wrote as to why you had decided not to prosecute in those matters.
That's correct.
Yes. Okay. Then can I ask you, paragraph 1.17 says, similarly, plus minus 50 cases from the DSO were finalized by McAdam and Ackerman. Are these 26 cases that are referred to, do they fall into that category of 50?
I assume so.
Okay. Then can I ask you then to go back to paragraph, PCJ 7 and page 1737. The first case is the Timol case. Who made the decision to close this case?
I think, and I speculate now what happened, is that Marga has got the job now to see what happened to all the cases. He then probably went to the docket or asked my secretary, and he went through our correspondence, and he saw that Chris McAdam wrote a query to have certain matters investigated, and he received a reply to it. That must have been now in 2006, and that no further investigations are expected. So if you ask me, I will take responsibility because I signed this docket. But I certainly know nothing about the Timol case. So you can rule me out, except that my signature is on this report, and I take responsibility for that statement. But I didn't make that decision.
And
I read somewhere that McAdam makes a point of it that he did not close the case because his name is not there. So, and I accept that then that he didn't close the case. I don't know why the case is then under TRC closed cases. But what I've read in the newspapers during 2017 and 16, that the evidence that came to light was only discovered in 2017 or 18, but at that stage when we had the docket, that and I'm speaking on behalf of Marga or McAdam, that there was no other evidence to investigate this matter. You know, and McAdam will be able, and Marga, to tell us what the position is regarding Timor.
Mr. Advocate Ackerman, I just want to say, the question was, did you take this decision?
No.
Okay. I want you to go next to the debt in detention of Mr. Steve Beaker. And you'll see there, this is one of the cases. Beg your pardon?
You need to speak up a bit.
Oh, I'm sorry.
Yes.
You'll see there that this is a matter that was also closed. Did you take this decision?
No.
Okay. Can I ask you to then go to page 1742B of that document and 1742B of the document. Those B were, there were 4 pages that was added to the original document that was presented by Commissioner Jacobs.
Yes, I'm listening. Now, once you...
And
I'm not...
Sorry, do you have 1742B?
Yes, I have it in front of me. There's a little print there once. Yes?
Okay. And I ask you to look at paragraph 2.23 of this document.
Yes?
Now, this is the refusal of amnesty to the President and other high-ranking officials.
Yes?
Who took this decision?
I took it, and Chris at the later stage wrote an opinion about it.
So, in regard
We were
to...
both involved.
Okay, but you have personal knowledge of the basis on which it was closed.
That is correct.
Okay. So this is what is said in this document. The TRC refused amnesty to the President and plus minus 37 other high-ranking ANC members, certain of whom held ministerial positions or other key positions in government. 2, the TRC found that they had not disclosed that they had committed specified crimes. 3, there was no evidence implicating them in criminal offences and the file was closed. And 4, the NDPP, Mr. Nguka, made a media statement to this effect as the DA was making an issue of the matter.
Yes, yes.
That's what's contained in here. Now, I just have a couple of questions for you, Mr. Ackerman. Firstly, we know no amnesty was granted to
Yes.
this category or this group of applicants.
It's correct.
And secondly, you say that there was no evidence implicating them in criminal offences, and therefore the file was closed.
That's correct.
Can I ask you, what investigations were done to come to that conclusion?
Let me think. I had this docket, and you saw the note that I've written. What happened before that is Brits brought me the docket. I read it, and I saw it, the landmines. Most of the docket consisted of, I think, of how there was an explosion and people were killed, and the type of mines, and it was, I think, that all the documents that was filed at the inquest. So it's actually the inquest that we had, I think. Then I had a discussion with the investigating officers, and that was this Brits and Nell. And I said to him, what do we have? And they said to me, they have this judgment of the TRC where they admitted that it was the landmine campaign, they were connected to it. And I told them that evidence is inadmissible. It took me a long time to explain to them. They said, yes, but I admit it. I said, it's inadmissible. So take it out of the docket. It's not evidence. Now, what do we have? At some stage, this must be a month or two, they said, yes, but the Foundation for Equality Before the Law, General van der Merwe, they have a docket and it proves the crimes. So, well, get the docket. And, over time, you see, in fact, Lisk went to the General van der Merwe and asked him for the docket. They never gave the docket to Lisk. So we're back to square one. I said to the policeman, now, if we must get some evidence. And what I'm interested in, I think Wagner told me that they have in the docket are the minutes, the agenda, who was present at these meetings in Lusaka. And I then conveyed it to Brits, Nell. Will you be able to get me this information that I needed? Because at the back of my mind, I know I can, of course, apply for legal assistance, mutual legal assistance, but there's no chance that they will, with a mutual legal assistance request, obtain those minutes. I think, they brought me some newspaper clipping. I don't know, maybe it's Shabas or what. I said, listen, this is not enough. You must investigate it. And all the time I said, yes, but General van der Merwe has the docket. And I don't have to explain to you what happened between me and Wagner regarding this docket and AfriForum. Everybody talks about this docket. I've never seen the docket and therefore had no evidence. If you ask me, that's it. Is there anything more that you want?
Can I ask you, were warning statements, for example, taken from the 39 persons who were allegedly implicated?
No, there's no evidence against them.
And that's on the basis of what you've just said. That's the nature of the inquiries that were made. That's the nature of the investigations that were done.
Yes. You know, I was waiting, of course, that they were going to be they said they're going to privately prosecute the president and all these people, and there were these threats over a period of years. And I was waiting. As soon as they applied for the private prosecution, I will tell them, show me the case that you have, and they're obliged to give me the docket, and then I can peruse it and I can see if there is evidence. I was at all the relevant times with the view, and I'm still is, they are bluffing. Even senior counsel that said there's a case, I don't believe it. Because happening, and they had this case.
Now, can I then, can we accept that that is effectively the nature of the inquiries, investigations that was done in respect of this matter?
Yeah, as far as I can recall.
And I take it, given the fact that it was an important case, you would remember all the important matters arising from this case.
You know, also I will remember it and test me. I have to state also that there's on the law, Chris McAdam wrote a long opinion why you can't open an investigation. I know there was an opinion, and it was given to Mr. Luca.
But at the end of the day, Mr. Ackerman, the long and short of it is you made the decision.
I read somewhere that Chris McAdam said he made the decision, but I take responsibility, full responsibility for that decision.
Okay. Now, let's leave that aside. We know the number of cases that were prosecuted as certainly at 2015, and I'm just taking it to the extent of your knowledge, and we know the cases that were closed during your time, or certainly the cases that were closed in 2007 are listed, or 2006 are listed in PCJ 5. Now, can I ask you this? One of the issues that arose, and I raised that with you earlier, was the fact that you needed investigators, and you had approached Commissioner De Beer, and he had given you, he had refused in a sense, and then you approached Mr. Nguka, and DSO investigators were provided for those 6 cases. Is that
That's
correct?
correct.
Yeah. Did you make any further applications to the NDPP for DSO investigators?
No. Because there were no investigators. I can't even recall we've requested for the 6 cases to be investigated by the DSO. Perhaps you can refresh my memory. Who were these 6 investigating officers investigating those 6 cases that Mr. Nuka applied for?
Mr. Ackerman, you know that you would have said this to many witnesses. It is my task to ask questions and yours to answer the questions. You know that.
Yeah, that's in a court of law. But But we have a commission that we need to obtain evidence what happened. So if you say it's same rules as in the court of law, I know the rules and I'll stick to it.
Yes, I would just rather, while I am questioning you, we did stick to those rules. Now, just coming back to the investigators that you asked for. In addition to, so you didn't ask for any further investigators after Mr. Nguka had given you the investigators for those 6 matters?
No, because I think I didn't have investigators for the first 6.
So are you saying that you made application to the NDPP, the director, the head of the directorate appoints the investigators, and you say that the investigators were not appointed?
I can't recall who, even if investigators were appointed, because I can assure you in the Shakani matter there was no investigator.
Advocate Ackerman, can I ask you, you say that you made a request to the head of the Office for Investigators because your unit was tasked with investigating TRC matters. You are given a document which says these investigators are provided to you, and you say that the investigators were not provided. Is that your evidence now?
As far as I can recall, because I had no investigator in the Shakani matter.
Mr. Ackerman, you've heard my question. Are you saying that no investigators were appointed, notwithstanding that you had a document saying that in respect of these 6 matters, investigators would be appointed?
As far as I recall, no investigators were appointed, but as I say, you know, I trust Mr. McAdams' evidence. I can't recall that investigators were appointed.
Okay.
But Mr. McAdams will be able, he's got an excellent memory.
Yeah. Now, can I, and we know as a matter of fact that you didn't ask for more investigators.
In relating to which?
No,
case?
in relation to any other matters.
No, we only asked for the 6. And I think because investigators were not appointed for those 6 matters, will serve no purpose to appoint, to ask for investigators in 26 other matters.
Now, Mr. Ackerman, that brings me to this point. Did you tell the NDPP, look, I've asked for these investigators. I have a duty in terms of the responsibilities you've placed on me to investigate these TRC matters. You've told me these investigators will be appointed. They've not been appointed. Please do something about it. Did you do that?
No, Mr. Duka gave evidence to the effect that he's not bothered with these things. Dr. Ramaiti and McCarthy must sort these matters out.
No, Mr.
That's not the
Ackerman.
question, Advocate Ackerman. Did you go back to the NDPP?
No. I went back to Ramaiti.
And you told him that this difficulty existed?
He's aware of that.
No.
Did you tell him? That is the question.
More than once.
And what was his response?
You know, thinking back, he will say to me, well, yeah.
So he was indifferent to your difficulty?
Everybody was.
No, it wasn't that then the time to go to Mr. Nguka and say, because the difficulty, as I understand, the matter that Mr. Nguka testified on was the dispute between whether it should be the DSO or the SAPS. It had nothing to do with the DSO not providing, having been authorized by or directed by him to provide the investigators.
He is aware of the problem, and he told me, I think he gave evidence to that effect. He asked McCarthy and Ramaiti to sort it out. And he knows none were appointed.
So effectively, as I understand your evidence, Advocate Ackerman, everybody in the NDPP was aware that a directive issued by, everybody in the NPA was aware that a directive issued by the NDPP was not being complied with, was therefore delaying the processing of TRC investigations and prosecutions, and nobody did anything about it. That's the thrust of your evidence.
No. Only the PCLU was aware of it, Mr. Nguka was aware of it, Mr. McCarthy was aware of it. Who else? You know, I didn't go to the commercial crime persons. There were lots of people, so the whole NPA was not aware of it. But I must say, McAdam and I told everybody that we saw is that we do not have investigators. I mean, you can just look at all the documents that you have on this matter. I'm now talking about Parliament submitting reports to Parliament. Stating a very unsuccessful year.
Mr. Ackerman, Mr. Ackerman, the upshot of all these problems is that the investigation and prosecution of these cases were delayed.
That's correct.
And on your version today, this is due to the fact that, or partly due to the fact, that a directive issued by the NDPP to provide investigators was not complied with.
Correct.
Throughout your period at the PCLU.
Correct. I mean, I'm off 2007, so it's not the whole period. 2007, I didn't do any operational matters. I had concerns when you saw those letters where I had a meeting with Ramaiti. It must have been here in 2008. I was then off for a year, but I had concerns about the PEPCO matter. I had concerns about matters not being followed up. I can't recall what I've stated in that letter, but that was a managerial job I had to tell him that I think McAdam must now be in charge of these cases, so that if something happens, now I suddenly realized. McAdam at some stage said he's in contact with Commissioner Lala and Lubea, and they said they will investigate. But nothing happened. Mr. McAdam can tell you all the steps he took to obtain, to get investigators during the period 2008, 2010. There are documents. I did not go through these documents, but I saw there's a trail of emails that McAdam sent to these commissioners and to Ramaiti. It's all, I haven't read it. It's before the commission.
Mr. Ackerman, I must please implore you. Please answer the questions I ask, and only those. Now, I'm coming
Because the
back.
others doesn't suit you.
No, Mr. Ackerman. There are rules of engagement. You know the rules of engagement. I am raising with you a particular matter, and that matter is this. One of your complaints was that you don't have investigators. You go to De Beer, Commissioner De Beer, he says, go to the DSO. You go to the DSO, or you go to the NDPP, and he gives you or authorizes that to be done. If you were keen on prosecutions, you would have ensured that those investigators were made available, and if they were not made available, you would take steps to ensure that that authority was complied with.
After this long question, I was keen to prosecute in TRC matters.
That's your answer.
Yes. Except if you dispute it, I can carry on.
Mr. Ackerman, can I ask you, in respect of DSO, or the DSO not providing the investigators that had been promised, is there any written complaint that you made, you yourself?
What complaint to what? About investigators?
Mr. McAdam, Mr. Ackerman.
Any written complaint, Advocate Ackerman, that you addressed in respect of the non-compliance with the directive by the NDPP?
I can't remember now. There might be some documents.
All right, but there's no evidence to that effect. Let me then, because we know, and we've been on this topic for about 15 minutes, and we know that DSO investigators had been authorized to assist. You now say, for the first time, that they didn't assist and nothing was done about it. So let's leave that aside for the moment. I want to go to something else. At the interdepartmental task team, there were issues now about the police assisting in these matters. Do you remember that?
Yes, I said they will assist us. Jacob said so. I think, in fact, he said he's written, his faxes were sent, and he will assist us.
All right. Now, were those offers that he made, and if I can just refer you to the letters, or the letters from that he had drafted for Commissioner De Beer, were those offers taken up?
Where are these letters? May I have a look at them?
Yes, I'll just show them to you in a moment. If you look at PC 17, you'll see a letter that he wrote to Commissioner De Beer. This is Commissioner Jacobs wrote to De Beer saying, please, we need investigators for the following matters. Are you there?
Yes, I see it.
Okay. And that issue was discussed at the interdepartmental task team meeting. And then if you go to PCJ 18, the provincial commissioners were asked to provide investigators for specific cases. Did the Did the PCLU take up these offers?
Of course, we're looking for investigators. If you want, I didn't write a letter back stating, oh, thank you very much for all these investigators. What do you expect me to do? They offered these investigators. I don't know if they were appointed.
But so the offer was made, and as I understand it, that was your request, that we want investigators. I'm just trying to work out what is it that stopped these investigations.
I think that it is Commissioner Celebi.
And so all of these letters that went out to the different provincial commissioners, you say, were of no consequence.
You know, I think perhaps Jacobs will be able to give evidence on that. Well, you know, I don't think they were appointed. It's not that I made offers to them, it's their duty to investigate.
Mr. Ackerman, just like it was your duty to prosecute, am I right?
Yes.
Now, in order to ensure that those prosecutions could come to finality, investigators had to be appointed.
That's a crux of the matter.
Yes. And I'm saying to you, on the evidence that was presented by Mr. Jacobs, that is what happened.
Did he appoint all these investigators? I was not aware of that. Must have missed it somewhere.
Did you not pursue this matter, Mr. Ackerman? You were told at these task team meetings that investigators would be provided.
You know, let's start with all these cases. Were investigator, I don't know whether an investigator was appointed for the Pepco case. I don't know whether an investigator was appointed for the Craddock case. He says somebody else was appointed. I don't know whether an investigator was appointed for Hanti Botha and others. I don't know whether an investigator was appointed for Kutsia. I don't know whether an investigator was appointed for the Kossa Spor matter. I don't know whether all these cases, I don't know. If you tell me they were appointed,
did you make inquiries?
I must say I didn't know about it.
You didn't know about what?
That investigators were appointed.
Sure. Mr. Ackerman, I've got to say something to you. The thrust of your complaint, as I understood it, from all the affidavits you've written regarding these matters, was that the reason that these prosecutions didn't go ahead was because there were no investigators that were appointed. And now you say today that you didn't know if investigators had been appointed.
I say that because I'm of the view they were not appointed.
Did you make inquiries?
I thought to ask Mr. Sonis.
But Commissioner, Mayor, I'm entitled to ask the question again. Mr. Ackerman, did you make inquiries?
Of course, there would have been inquiries. You can ask perhaps McAdam will be able to tell us, or whoever. They offered, they had a duty to investigate. Did they appoint it? If the evidence is from the police that yes, for each of these cases, we appointed the investigator,
Mr. Ackerman.
then that's the end of the matter. But these
Mr.
cases were
Ackerman,
not investigated.
Mr. Ackerman, just listen. Did you make inquiries? No, I
I-
didn't make inquiries.
Yes.
I made inquiries, and then wait for the follow-up question.
I can't recall. That's the best answer to everything now.
Mr. Ackerman, may I ask you one thing, and just tell me whether you agree with the general proposition I'm making. I know you agreed when I said that it seems as at 2015 that the record of prosecutions was dismal. You agreed with that proposition. Is that correct?
I would say, yes, it's dismal, but I'm not the cause of it. I was keen, and all the documents were reflected.
Yes. Now, Mr. Ackerman, it's not for me to say who was responsible. It's for the commissioners to make that.
You've already
that
made a
decision.
statement to that effect. I said you've already made a statement to that effect, that I was not very keen to investigate.
Mr. Ackerman, I was responding, but be that as it may, I can make a statement, but that is not binding on anybody, certainly not on the commissioners. The question I want to ask you is this. These matters have not been finalized from 2003, when the investigation, when the prosecutions ought to have started in earnest. Am I correct?
Till 2017, yes.
That 2017, you say?
Yeah.
Okay, that's the period that you may have been involved. Anyway,
I was not involved in it. I retired 2013.
can I ask you this? When one looks at the picture as a whole, the fact that there is this dismal result in regard to investigations and prosecutions appear to be based on two possible broad reasons. One is what Mr. Wagner has told you on so many occasions. But look, man, we are all wasting our time in this. There is going to be no purpose served by prosecuting these matters, because at the end of the day, the generals and the leadership of the ANC has made a decision that these matters will not be prosecuted. That, as I understand it, is more or less what Wagner told you as a general proposition. Would I be correct?
Yes, it appears to me he was right that all the politicians were involved, that there will not be any prosecutions. And they were drafting. Carry on.
I'm asking a different question. I said, this is what Mr. Wagner told you.
Yes. And with hindsight, it appears to me he was right.
Okay. The other issue perhaps relates to this. You will remember that I started with the letter by Commissioner De Beer saying that we will not investigate our own. And I said to you that reflected a reluctance to investigate, by the police to investigate their own. Now that's the second possibility that exists, and I'm just giving one part of that second possibility, namely a reluctance on the part of the police. In addition to that, in his book relating to the TRC, well, in his the part of his book relating to the TRC matters, Reverend Chikane says that there appeared to be no appetite to pursue the TRC matters on the basis that the past is the past and we must move on. That's part of what is reflected in Reverend Chikane's book. Now that's another possibility. Would you accept that?
Yeah, many possibilities. I accept those two.
And then the third one is that it is this tussle about turf between or among the following. Firstly, the police and the DSO on the one hand, where the police thought that the DSO were hogging the headlines and doing all the cases that appeared in the media, and they were, in a sense, asked to do the more, the lesser well-known cases. And then between the NPA and the investigating arms that have been created, namely the DSO and the police, and it is that inability for them to look to the greater good of the victims of apartheid and the abuses that were suffered that, in fact, is the cause of the delay. Would you accept that?
I accept that. But Chair, can I just ask something? We can sit till 9 o'clock tonight, but we must finish it today, the cross-examination. Because it's last time you see me.
On that score, Mr. Sonny, how long do you still have to go with your cross-examination?
I don't intend to be much longer.
We have re-examination to conduct before we can excuse Advocate Ackerman.
Yes, no, I understand you, Best.
Yeah, that was the third scenario, third possibility. Is there a fourth?
Can I take a minute? Commissioner Como, I do not have a third possibility. There may be, but
The fourth.
of course my analysis must be limited. I'm just one of the persons that are involved. It's a matter that has spanned for a long time. But these are the three possibilities. Now, Mr. Ackerman, may I conclude my cross-examination?
Mr. Sony, can you come closer to your mic?
Oh, I'm sorry, Commissioner. May I conclude my cross-examination, Mr. Ackerman, with this? At the end of the day, the Commission, and of course, in part, the evidence leaders trying to lead evidence in that respect, will have to determine who was responsible for any, well, firstly, whether there were attempts to stop the investigations and the prosecutions of persons who should have been prosecuted in terms of the TRC mandate. And from what we have through your evidence and the evidence of people associated with the NPA and the police, it would appear that we won't be able to identify at this point who in particular was responsible, but we can say institutionally it was the NPA and the police. Anyway, that's what we submit are the institutional culprits, if I can use that word.
Do you have any response, Advocate Ackerman?
None. Mr. Chair.
I have no further questions, ma'am.
Thank you. Mr. Vani?
Thank you, Chair. Just a few questions on re-examination. Mr. Ackerman, if we can just start with the questions my learned friend, the evidence leaders, put in relation to the De Beer letter. That's the 26th September 2003 letter from Commissioner De Beer to yourself. Do you have a copy of it?
Yes, I have it in front of me.
It was just put to you that in that letter, De Beer said or intimated that we will not investigate our own. We will not investigate them as in police investigating police. Is that anywhere in this letter?
I can't recall whether it.
Okay. Well, I can tell you that
And it's not in there if I think about it. But I just read it now. I can't see it.
Yes. But what is there is the sentiment that a number of cases to be investigated are those of ex-policemen. Therefore, it's understandable that you first endeavour to have these cases investigated by the DSO. Can I ask the investigators with the DSO, the detectives that they had, were they either former SAPS or seconded SAPS investigators?
They were, I don't know whether that's a seconded, but I know most of them, they were all policemen.
Yes. So even in relation to the DSO, if that was a concern, you would still have policemen investigating policemen.
That's correct.
And in that same paragraph, just to tie up some loose ends, it stated that the prosecution of these cases were referred to the NDPP by the President. Are you aware of any presidential proclamation in which the President directed that the TRC cases had to be investigated by the DSO?
No, I don't.
Now, the only thing I can think of is that in the President's speech in 2003, he made mention of the fact that the NPA would proceed with these cases in the normal course or something to that effect. Do you recall that?
That's correct.
And it's understandable that prosecutions in South Africa are handled by the NPA, but could you read into that the NPA would then also handle the investigations.
Because the police handled all my investigations. I'm not talking about TRC investigations.
Yes.
Only TRC cases were excluded.
Yes, and in the absence of such a proclamation, under the NPA, actually rather under the SAP's legal mandate, they had the authority to investigate crimes, especially serious crimes like kidnapping and murder.
Correct.
At any later stage, did the SAPs ever put up this issue of police investigating police as a reason why they shouldn't investigate?
I don't know if any, yes, I think I read that for the first time in his letter. Police investigate, when a policeman commits a crime, it's policemen who that investigate them. Can I just have a look at the Mandlanga Commission? It's the duty of the police to investigate.
All right, let's move on. Now, it was put to you that at the end of 2003, the NDPP, at that time, Bulelani Nguka, was asked to make a declaration in respect of 4 cases, and that was issued on the 24th of February 2004. And the 4 cases were PEPCO 3, Brian Ngulunga, the Motherwell 4 case, and then the Frank Chikani matter. And then shortly thereafter, two further matters were added, the St. James Church attack, as well as the attack on the Heidelberg Tavern. And you've testified that as far as you're aware, investigation officers were not supplied in those matters. And we've just taken a quick look at the McAdam affidavit. And this is in a few places. We're looking at bundle 8, page 280, at paragraph 23. And if you look at paragraph 22, he makes reference to the letter written to Ledwaba by Ackerman, dated 11 November 2003. I'm not going to go into that detail. Next paragraph, Mr. Ackerman says, the DSO, however, did not appoint investigators as requested, and consequently none of the TRC matters requiring investigation could be taken further. Is that your recollection?
That's correct.
But let's look at the individual cases, and let's try and do it as quickly as possible. The PEPCO 3 matter, as I understand your evidence, I think you might have mentioned this in your evidence in chief, that had been investigated previously, and indeed, the record shows that the PEPCO 3 accused, or at least some of them, appeared in court and indicted on the 11th of February 2004, which is about just under 2 weeks before the NDPP issued his declaration. So in that case, it appeared that those investigations had been largely complete, given that the matter had already been enrolled before the declaration was issued.
Correct.
Ackerman?
Correct.
The Chikani matter, as I understand your evidence, had already been well developed and investigated. You did mention that you yourself had to conduct certain inquiries, even having to go to the US to collect a toxicology report, but that the inquiries were largely done by 2003. Is that recollection accurate?
Correct.
And let's turn to the other matters. The Motherwell 4. In that matter, I understand that convictions had already been obtained in the early 1990s, but that there might have been a further angle or lead to pursue on that matter in relation to Krappies Engelbrecht. Is that your recollection?
I don't think I specifically dealt with the matter to say that no investigating officer was appointed. I'm not sure. It's Chris's matter.
Okay, all right. Let's move on. The Brian Ngulunga case. Do you have any recollection as to what happened in that matter?
It was not investigated. It was investigated when the De Oliveira unit was still in place. I know there was a docket there. I don't know what then happened to the docket who investigated it further, but that's now quite early. That must have been in the late 90s.
Right. And then finally, the St. James Church and Heidelberg Tavern attacks. Were those developed any further?
I think Marga dealt with that matter. I think Marga and I don't know. Marga and Pretorius, I don't know whether the investigating officers were appointed. They both will be able to give you accurate.
Well, Advocate Maga has already testified, and his evidence is that he did what he could in a handful of cases. That's already on the record. But that between 2007 and 2009, because he couldn't get any investigative support and the cases were not being taken forward, he actually asked to be transferred to other matters where he could pick up court experience.
He mentioned quite a few matters that he investigated in the Eastern Cape. I know, I just read it. I just read his affidavit. Every time, you know of that.
Yes, he has testified. It's on record. It has been referred to. We don't have to traverse that again. Then let's turn to your 2015 statement. And it was put to you that certain matters did go ahead, and you outlined them in paragraph 16. And because there's some other matters, let's just deal with them. Well, there were four matters. The Eugene Terreblanche case, that's in paragraph 16.1 of your 2015 statement. The Blani matter, paragraph 16.2. Then the PEPCO 3 matter, and then finally the Chikani matter. As I understand your evidence in chief, those particular matters could go ahead because they had been previously investigated. In fact, in paragraph 16.2, I think you mentioned that the Blani matter had already been fully investigated.
That's correct.
And we have discussed the PEPCO 3 matter already. It was put to you by my learned friend, Mr. Soni, that although you had referred to the Chikani matter in paragraph 17, but that was only in relation to the arrests. You hadn't referred to the fact that the case did get finalized in court. If you have the statement in front of you, I want to draw your attention to, firstly, to paragraph 25. And if you look at the middle of paragraph 25, and just to save time, I'll read that sentence. However, with the exception of the Chikani matter, during the course of 2006 and 2007, the PCLU was unable to pursue any of the TRC cases for various reasons. You make reference to investigative capacity. And then let's turn to page 29, where you set out the detail. Paragraph 29. During 2007, the PCLU eventually returned to the Chikani attempted murder matter. And then you make reference to the charges and the plea and sentence agreement. I'm not going to waste time going through that. The Commission is familiar with it. So it is correct that you did deal with the Chikani matter in detail in your 2015 statement, including the fact that it had been finalized in 2007.
Yes, for everybody to see.
Now, if we can turn to the proclamations that you were referred to by Mr. Soni. So this is PCJ 17, where Commissioner Jacobs writes to Assistant Commissioner De Beer. That's an undated document. He also referred you to PCJ 18. That document is dated December 2006. And that document, PCJ, we're just getting PCJ 18. Is it in here? All right, in any event, my recollection is that PCJ 18 is the communication, I believe, from Commissioner Jacobs to provincial commissioners, requesting them to make officers available, and in fact specific officers were named for the provinces. Now, it was put to you that these two communications was an offer to the PCLU. Is that strictly speaking correct? What offer was being made to the PCLU, since these communications were not addressed to the PCLU? I don't believe you were even copied on them.
I haven't seen these documents. But I know that at some stage he did mention that people were approached to assist. But these documents, I didn't get any copies of them with the names.
Yes. And just for the completeness of the record, if we can go to the ITT minutes of the 4th of December 2006, that's at page 55, it's annexed PCJ 10. You were present at that meeting, and so was Commissioner Jacobs. I just want to refer you to paragraph 4.5. Commissioner Jacobs informed members that he has sent a letter to Commissioner De Beer, and the list of all investigators will be ready soon. So Commissioner Jacobs informs that he has sent a letter to Commissioner De Beer. And then if we can turn to the minutes of the task team 29th January 2007. That's at page 56 of the Jacobs bundle. It's Annex PCJ 11. And I'm just going to read you the second last paragraph. Commissioner Jacobs informed the meeting that he is waiting for a feedback from provincial commissioners on the appointment of investigators. Some had responded and provided him with a list of the investigators. He also requested a list of SAP's dockets in possession of the PCLU. Now, it was your evidence that you were not aware whether any investigators had been appointed. And actually, we can find no evidence anywhere in the record that these investigators were appointed. And we can refer to paragraph 62 of Commissioner Jacobs' affidavit before this commission, on page 16 of his affidavit, where he refers to preparing a letter for Commissioner De Beer's signature on the 6th of December 2006, addressed to the provincial commissioners in the provinces. And then he says, in this regard, it was reported to the ITT on 29 January 2007 that feedback was being awaited from the provincial commissioners on the appointment of investigators. So as far as we can tell, the last mention of these investigators was towards the end of January 2007, when Commissioner Jacobs reports that he's awaiting feedback. Now, we have evidence from McAdam saying that he was still asking for investigators between 2007 and 8 through to 2010. We have evidence from Advocate Maga saying that although he did what he could on his own and being innovative, he did not have any investigative support. So it does seem that there isn't any particular evidence, and perhaps if there is, I'm sure my colleagues will present it. But it does seem that, at least as far as the record is concerned, it supports your assertion that these investigators were not appointed, or certainly did not commence work.
Yes, I agree.
And if we can just go back to the proclamations that were issued in early 2004. And again, it's your evidence that, as far as you're aware, those investigators were either not appointed or did not commence work. In that same year, the moratorium was imposed towards the end of that year, at least officially. I don't want to traverse that evidence again, but you will recall that on the 11th of November 2004, when you attempted to effect arrests in the Chikani matter, and the evidence from yourself and Advocate Ramaita is that the minister then intervened, and the cases were then suspended pending the guidelines. That probably explains, at least from November 2004, why there was no attempt to follow up, because now there was an instruction that the NDPP was under to suspend work on these matters post-November 2004, pending these guidelines. Would that be correct?
That's correct.
No further questions, Chairperson.
Thank you, Mr. Vani. Advocate Ackerman, we thank you very much for having agreed to come to give evidence before this commission, given your health condition. That is greatly appreciated. You are now finally excused as a witness. Thank you. These proceedings, oh, Mr. Semenya?
No, I was just going to make the point that Monday is a DS known. It's a holiday.
Yes.
But in lieu of your direction.
Yes. These proceedings are adjourned until the 30th of May. 30th of April.
I almost got a heart attack.
These proceedings are adjourned until the 30th of April, 2026 at 10 hours.